Granted.
All right, good afternoon. We're on the record in case number D236766042D, Millard versus Millard. Mr. Schneider, your appearance, please.
Good afternoon, Your Honor. Louis Schneider, 9683, on behalf of Kendra Miller, Your Honor. She's present and live and in person.
Sounded like you said Ketter.
Kendra, Your Honor. That's my ex-wife, Your Honor. Sometimes I choke on it.
Oh, okay, that's what it is. Mr. Zernich.
Thank you, Judge. I'm Gary Zernich, and my bar number 7963. I'm appearing by Zoom for Anthony Millard. I'm in an unbundled capacity, and Mr. Millard is appearing personally. I see that he's there in your courtroom.
He is. Y'all can sit down.
Thank you.
Thank you.
All right. Mr. Schneider said that Mr. Zernich had some stuff to put on the record.
Is that how he put it?
That's how he put it. Well, he didn't say stuff. That's my words.
I asked some representations to me.
He said representations. I couldn't think of the word, so I said stuff.
No, Judge, I think the biggest issue before the court today is whether or not Kendra is rightfully in St. George. It's St. George, yeah. With the is it St. George or is it Mesquite? No, St. George.
St. George. It's Utah.
With the minor child, we had an order from the last hearing, and then there seemed to be some conversation between Mr. Schneider and Mr. Miller directly when I was just in an unbundled capacity in the last hearing, so that was not with my being present, and I have no dispute about that or argument. And then Mr. Schneider filed an amended motion to relocate, and my client recently filed an opposition. And by the way, that was filed in proper person. I was not. I did not assist him in preparing these documents. If I had, I would put some footnote on there that I was assisting in the preparation, so it would not be a ghost pleading.
Well, it is a ghost writing, so who wrote these documents for you, sir?
Just a family friend.
A family friend who argued the law, okay?
Your Honor, NRS 240A requires identification of who wrote these pleadings.
I know. Who is the friend?
Just family friend.
Who? I'm asking for a name, not just a friend. It is required to know, that way we know that it was not written by somebody where there's a possible conflict or anything like that. Who wrote these documents?
David Schoen.
David Schoen. Okay. All right. All right. Thank you. I appreciate that. Do you have a conflict?
I don't have a conflict, Your Honor,
Okay.
but Mr. Schoen is practicing law without a license, and the bar ethics require that the court file
Don't tell me how to do my job.
Your Honor.
You will be the fourth person today to try to tell me how to do my job, and it's not sitting well.
I just read the statute last night. It doesn't require the judge to do it. It just requires that a report be made to the bar on the unauthorized practice of law.
Then I'm not going to get into that. I might have a different opinion without arguing the law about the practicality of it. But that's I don't think we're here for that today.
No.
May I go on with?
Yes, you please.
Thank you, Judge. At this point in time, my client he just wants to clarify the opposition that he has presented to the court, and in the face of the emails that he's been corresponding with Mr. Schneider about a relocation. My client thought that essentially he was okay with Kendra going to Mesquite, but he thought of it as a
Mesquite or St. George?
St. George.
Okay.
To St. George, but he thought of it as a temporary order agreement in light of your order, and he's okay with it, except that he just feels like it's a trial period, and he would like the matter to still remain on the court's docket as part of a custody trial and or the divorce trial if they're combined. And if things are going well, then they could reach some form of a stipulation and order at a later date. But it's a big move for the child. It may or it may not work. I mean, we know that it's not across the country, but even in every week 2-hour drive with multiple drives during the week for the horseback riding
And
lessons.
that's what I have a problem with.
It's down to 2 days, Your Honor.
Doesn't matter.
Well,
That,
so-
okay, here's one of the problems that I have. Okay? And I have a possible solution. The child's being homeschooled, right?
Yes, Your Honor.
Why aren't we doing week on, week off with the child still doing their homeschooling and it don't,
Your Honor, we are. The
That-
parties went to mediation and agreed
Okay.
to joint legal, joint physical, week on, week off schedule.
see, I think, sometimes I come up with a good idea.
I thought you knew.
I did.
And you must
I
be
didn't
using the
look at that.
force.
and so my client, he is,
Well, I saw a motion
he's
for
okay with it
reconsideration, not the
as a temporary sort of trial period.
We have no objection.
He does, okay.
Okay, the key with this here is that this child, I'm going to call her a child, she's growing up quickly, you know, probably a lot quicker than what y'all want her to. You know, it happens though. She still needs both of you equally. And I don't like the idea of the child being on the road so much. I mean, it's dangerous. It's dangerous for the child to be on the road as much as she is. So are y'all in agreement to let's just try this out?
Yes, Your Honor.
And keep calendar call and keep everything on there, and then if the parties agree that this is working out fine, then we can just leave it like that.
Yes, Your Honor.
Judge, can we get Mr. Millard to give a oral response since I'm not there with him?
Yeah.
I want to make sure that we're all on the same page.
Okay, he's saying yes.
Oh, okay, thank you.
All right, I appreciate that. When you have someone doing writing for you, just have them sign to state that they're writing it for you on your behalf. Okay, that's all I'm asking. I am going to accept the parenting agreement then right now. We are going to write temporary until you tell me that you want it permanent.
Judge, they have permanently agreed, they have permanently agreed to joint physical custody arrangement.
Okay, then I'll do that. Does it mention anything about relocating to
It does not,
Utah?
they don't do that.
Okay, as long as it does not put that in there, then temporarily we'll allow the relocation. I'm just sitting here. Your boyfriend's going with you?
Yes.
Okay, all right. You know, I mean, I'm sitting here. One of the reasons why you wanted to make the move was that financially you couldn't afford anything, and you were needing help with. Is it one of your sons disabled?
No.
No.
No, they lost their dad.
They lost their dad. Okay, that's where the SSI is coming from? Mm-hmm. Okay. But, I mean, I did the math. And y'all make almost $9,000 a month. Between you and your boyfriend. With the SSI and everything coming in.
I don't know what his finances are in their mind.
Just based on what you put on here. Your financial disclosure, you have almost $4,700 a month coming in. And then he puts another $3,922. That's $8,588 a month coming into your household.
With the SSI, the last quote we discussed, it's my son's SSI.
Your Honor,
The SSI can only be used for the children.
Okay.
I recognize that.
That's in the child's name, therefore it's not income to my client, Your Honor.
Yeah. I'm just saying this is money coming in, but that's used towards rent and groceries for the kids. You got two of them, right?
Yes.
Is it,
Your Honor,
okay.
And one in college.
I have this exact same matter in another case.
Uh-huh.
And the judge said.
I would not touch that as being child support or anything. That's the other kids.
Okay, so you're not.
No. I'm just saying what's going into her household.
Okay, so you're not counting that?
No, I'm not
Okay.
counting that. That was just one of those comments that I was making. That is that I cannot count that as income
Thank
going
you,
to
Your
you. Just like I can count that the $39.22 that the boyfriend's bringing. I'm just saying, why are you moving to St. George with this kind of money coming in?
Well, he's not making that money right now. He's actually waiting surgery. He can't.
Oh, him too, huh?
Yeah, he tore his rotator cuff while working. He's a horseshoer. And it didn't heal properly, so now he can't rotate his arm backwards, from my understanding. Like
Yeah.
he's stuck.
Well, it's if you don't keep the arm moving once you injure the rotator cuff, it will freeze up. You have to keep it moving, or it will freeze.
I don't know the detail. I don't
Unfortunately,
know.
I'm learning the hard way.
His has to be reattached or something like that. So I
Okay,
can get those if you need.
They're
to.
gonna have to snap it and redo
He's
it.
working very minimal.
Okay.
He's doing about 4
All right.
sessions a week.
So,
Or a
are
day.
we going to do anything regarding child support. I wish do you still get unemployment?
No, I work.
You work?
I make
We're
it.
filing a new FDF, Your Honor, she's making $15 an hour.
Alright. Can I count on y'all to figure out the child support?
Gary Zernich and I will work together to calculate the child support,
Okay.
Your Honor. And,
That-
and Your Honor, I believe that if Gary stays on this case, I don't think we're gonna go to trial. I think we'll be able to resolve all the issues.
I do too. If you,
My
you know,
only
with the
issue-
money that you're making,
I was making. I'm not making as much now.
well then you need to do a new financial disclosure form as well. Because I still show you're making $16,000 a month.
Yes, it is less. Since the beginning of the year, I'm at 26.
So, you know, you want to. Okay, this is a very important detail. You know, not necessarily something. I mean, I know it's your kids, and you know she's going to take care of your daughter. You know, when she's not with you. But there's other little details that may slip through the cracks if there's not two attorneys involved. So keep Mr. Zernich on. He's worth it.
The only reason I haven't retained him is because I haven't had the funds to do so.
Okay. All right. All right. Try to work together.
We will, Judge.
I'll sign this agreement. Do we need anything else? Because we do have calendar calls scheduled for September.
Your Honor, I'm gonna ask that the pleading be stricken from the record. It was filed 24 hours before this hearing. It was ghostwritten, and
I haven't even looked at it. That's that's why I didn't even know. I didn't know it was there until I looked.
I'd ask that it be stricken from the record, Judge.
I'm going to leave it there because it gives me something to read later on. Okay, if we go to trial, it at least lets me know that it's not necessarily something that I'm going to use. It just gives me a history because I don't get pretrial memorandums from a lot of attorneys. And I don't know if Mr. Zernich is going to be there or not, so I at least have something there.
Okay, Judge, I understand.
That's the only reason why I'm not going to strike it from the record. However, things need to be filed within 14 days. This was not an order shortening time, was it?
No, you never granted
Okay,
the shorting time,
yeah.
Judge. and I have
So
no
you know, you got 14 days from the date that you receive it. So to file an opposition counter motion, or normally it would be stricken. I'm only leaving it there because it tells me your side.
Your Honor, there's no time for me to file a reply, but
That's
may
okay.
I renew the motion if after the case ends?
After the case ends?
Yes, Your Honor.
For
I just don't like the ghost written. It doesn't comport with the rules.
I know it does not.
And so if we leave it there temporarily, I will renew the motion later. So if it's okay with the court.
I'm not, I like to interject on that. I don't believe there's any reason to strike his opposition. It's common practice in the court that people are using outside parties to assist them with drafting these things.
It's obvious it was written by someone out there.
We have the Equal Rights for Divorced Fathers that for 22 years have been doing this with 5 paralegals over there, and there was never anything on there, so I don't know what the purpose of it is now.
Well,
The rule change.
yeah, we did have a rule change where things cannot be ghost written any longer. It has to state who it is that is actually doing the writing here. And the person who runs Equal Rights for Divorced Fathers is very good at making sure that his name is on everything that they do at this point.
Yeah, and I was talking about in the past, because I know
Yeah,
it's taken,
yeah. In the past, yeah, I agree. You know, in the past, it was something that was done all the time. All I'm doing is just asking Dad if you have someone come in and write something for you, that they just say who it is that's doing it.
Understood.
That way, it's that way all the proper things are in place. Okay.
Judge,
Understood.
Judge, I have one issue I'd like to bring up about this temporary order and the relocation, because I don't think it's in the prior order, because the prior order didn't address it because there was no relocation yet. My client is hoping that Kendra is going to be responsible for 100% of the transportation to and from Las Vegas.
Agreed.
She's the relocating party. And he
They're
should not-
agreeing to it,
Okay, thanks.
so we don't need to argue that one. Okay.
It's gonna have to be a record, Judge.
I'll do it, Judge.
I'm going to sit here going, okay, who am I going to do? I'll let you do it. Yes, sir.
One more question. Is it possible to adjust the temporary maintenance? You ordered a $1,000 temporary maintenance on top of the $1,200 child support.
It's not properly before the court, Your Honor. I'd ask that we address this all when we get with Gary, with Mr. Zernich.
Let's address it with Mr. Zernich. However, it may not be properly before me take out the 2,100, and the rest of the money that is there is the boyfriend, and he's not legally responsible for her. So I just mentioned how much money is going into the house, so, you know, but there's no legal right to that money. Okay?
Correct.
I'll deal with that later. We're good, Judge, thank you, Your Honor.
All right.
Is my-
But she's making an income. We don't have updated financial disclosure forms from her, so get it filed and address it with Mrs. Zernich quickly.
Yes, Judge.
Thank you.
Thank you, Your Honor.
Thank you.